community gardens, if you get in on that.
Ready to
work up
roll?
the soil
Okay.
and give you some seeds. and
Welcome,
plant.
everyone. Thank you for taking time out of your day, your week, your month, the busy month of May, to be here tonight. And I hope you'll get something to take home with you this evening. So my name is Gary Vought. Sounds like trout. And I'm gift planning counselor with the LCMS Foundation, and I serve in the North Wisconsin District. So helping congregations and individuals and members with gift planning and their estate planning. And so good to be with you tonight, and kind of a focus tonight a little bit about on children and what does that mean for us as we're parents, and what things should we be thinking about. So you think of the word estate planning isn't just for the super wealthy. Well, the word estate actually means all the money and property owned by a particular person, especially at death. So that's the definition. So almost everyone has an estate. It isn't just for the wealthy, and so that's what we'll be talking about. So I'm glad you're here. Let's join in a word of prayer, if we would. So, Heavenly Father, thank you, Lord, for this evening and safe travels. We pray, Lord, you bless this time together as we focus on and learn perhaps a little more about our own estates and planning for those things and making decisions into the future that can be blessing to our children and the rest of our family and the rest of our lives. So be with us and bless this conversation and all this in Jesus' name. Amen. All right. So our goals for today will be a little bit about the LCMS Foundation, who that is and what we do. What is gift planning and what is estate planning, and how does that fit perhaps for you going forward, and what does that mean? Understanding terms like last will and testament, revocable living trust, power of attorney, beneficiary designations, things like that. And then hopefully you'll be motivated, if you don't have a plan completely finished, to get started on that after our time here together also. So a lot of people talk about it, think about it, and a lot of people never get it done, unfortunately. So the LCMS Foundation was started in I gotta trust my clicker so I don't turn around every time. We started in 1958, and really two main goals of the LCMS Foundation. One is to help people with gift plans so they can leave gifts to the ministries they care about. And then secondly, we help churches and universities and institutions of the church with their long-term investments, so they can make more from the money they have and do more with ministry into the future. So there's about 22 others of me around the country that do the same work in different districts and in different ministries across the country. And then down in St. Louis, we have people that make it all work for us, including attorneys that make all this happen. And so that's kind of what we're about. This last year, we worked with people to create 803 gifts for ministry gifts into the future. So that totaled almost $140 million. That people sat down, put a gift plan in place, so when they passed away, those dollars would go to support the ministries they care about. And then we also this past year distributed gifts of about $38 million. So those went out to different organizations like churches, like here at Peace, and schools. The LCMS Incorporated, which is our large church body in St. Louis with about 6,000 congregations across the country. Different LCMS ministries, our districts, seminaries, universities, and then other charities that people wanted to support through their gift plans also. So some of those ministries could be like Lutheran Hour Ministries or Lutheran Bible Translators or the LWML, some of the ministries people give to. And then we also have 1.1 billion under management. So, and with that, we're helping those dollars grow so that those long-term investments can create more money so ministries can do more with that into the future. So we're not a bank or a credit union. Don't confuse us with the LCEF, which is another great organization. But we do long-term investments, and then we sit down with people to plan their Christian estates and complete those goals that they have for their estate plans with their giving and so forth. So, all right, let's talk a little bit about an estate plan. So, somebody read this for me? Would somebody like to read that on the screen? Yes.
A plan for managing your assets and wealth during your lifetime and after you pass away. It involves determining how your assets will be preserved, managed, and distributed, and deciding which people or organizations receive your possessions. collection of documents that outline your wishes and instructions for your care and assets if you die or become incapacitated.
All right, so your estate plan is a plan, just like it says. And it's about managing those assets, putting a plan in place so we can say where they're gonna go when we pass away. It can be changed, it can be reviewed, it can be revoked usually with the things that you decide. And so what are assets? When we talk about managing assets, what does that mean? Well, that can be property, it can be your investments, it can be savings accounts, retirement accounts, it can be your personal property, and it can be businesses that you may own. And so all those things are gonna go somewhere when you go to heaven someday. So putting a plan together, make sure that you are deciding where those things are gonna go rather than someone else or the state of Wisconsin determining where those things might go. And so then finally, it's a collection of the legal documents that your attorney or our attorneys might help you develop so that when you do pass away, those things are gonna happen just as you wanted or intended those things to take place. So that's an estate plan. So what keeps us from doing an estate plan? Why haven't we done this yet? So there's a lot of reasons, and people have all kinds of excuses, and we had them too, my wife and I. Some people think it's too complicated and they just glaze over when you start talking about legal things and finances and taxes, and it's just not a lot of fun. We might be too busy or too stressed to talk about these things. It's not often a fun thing to do, so it's so serious that many of us don't want to get it done. Expensive. There can be legal fees involved in getting your estate plan done, to get a will done, or to get a revocable living trust or other documents. There can be costs associated with that. And then some people just think we're too young and healthy, and there's no reason to worry about this right now. Or estate planning is only for very rich people, and so why would we think about doing that? And so those things get in the way of people getting it done. But the good news is you're here today to think about these things, and hopefully it's the first step towards getting your estate planning and your gift plan completed. All right, so since we're the church, we talk about a Christian estate plan. So what's different about that? Would somebody read this screen for me?
Sure. Assessing and organizing our assets, our earthly blessings to provide gifts for both family and ministry. Finding the best assets to give, the best methods to give them, to make the best gifts for your family and ministries you care about. Gift plans are accomplished via wills, trusts, beneficiary designations, and various gift planning instruments, taking care of our final affairs on behalf of family and ministry.
Okay, so it makes as Christians, as we think about what may happen when we go to heaven one day, is that not only do we want our family to get an inheritance, but we can think also about how about we carved out a piece of our estate so that the ministries we care about, like peace or other ministries we care about, might get a portion of our estate plan also. And along with that, as I work with people on planning their estate plan, then we think about what are the best assets to give. Is it this account or this investment? Or what are the tax ramifications when we think about passing something on to family versus passing it on to ministry as a charity? So what are the best gifts to give along with supporting your family? And really, inheritance, that you can think of stories in the Bible where inheritances were passed down right also. So that's not a bad thing at all. In fact, it's a way in which we care for our family now and into the future is by putting an inheritance together. But can we also think about the Lord and His church and the ministries we care about during this time also? And so we want to get the best assets and the best methods to give, and then get the legal documents in place to think about that. So think about yourselves right now. How has the Lord blessed you? Let's take a moment. Either choose one up there or another thing that you want to share with the group here. What is one blessing in your life that you'd like to share? Keith, can you start?
Probably family. Above any material things, and family and faith are most important to me.
All right, great. Someone else? Yes.
We have relatively good health. We don't really have anything in our family or immediate family or parents or anything that we,
Wonderful.
yeah.
That is a blessing. Yep. Someone else? Another, what blessing do you think about today when you think about all that the Lord has given to you?
Christian parents and so forth, that teach you right from wrong from the very beginning.
Nice.
Go to church.
Yeah, good for you.
I was gonna say, being a grandparent
Mm,
is a new blessing for Shelby and I over these last few years, so
definitely.
nice to be in that
I agree with that.
phase of life.
Absolutely.
This is where my husband says spouse.
Oh, yeah.
Spouse, yes.
Don't forget your spouse.
And if you look on the right side of the screen from Psalm 9:1, it says, I will give thanks to the Lord with my whole heart. I will recount all of your wonderful deeds. So it's important for us, and one of the things that makes this a spiritual process is to recount all the blessings that we have in this life and the many ways in which we are blessed. Those different words up there, and maybe there's others in your own life also. And so going through this process is a great opportunity to think about all those blessings and what you want, where you want some of those blessings to go when you pass away and go to heaven one day. It's really about focusing on gratitude and a focus on the Lord and all that He provides for us. And this is really something that can motivate us to think about giving back. And maybe a portion of our estate can go towards ministries that we care about as well as our family. So, what will happen to your blessings when the Lord calls you home? So some of us can't answer that maybe. We don't know everything, but let's work towards putting a plan together so we have some certainty about those blessings and what might happen to them when we pass away one day. So do we have a will or irrevocable living trust in place? Do you have beneficiary designations that are up to date? What will happen to your children? What about taxes and how will that affect my estate? And then what is probate? So all kinds of questions that can pop into our head as we think about this whole process. So as we work with people, we sit down, and the whole process we call the lifetime plan for giving. And it's a way to take an inventory of all the blessings that we have in our life, and then we can work with you and sit down and help to put together a plan to see where those things might go. It's a Christ-centered process, so we want to keep Jesus as the center of all of this, and it's really about stewardship. And that's a word we use a lot at church, right? Maybe not so often in the rest of our lives, but being a good steward means taking all the blessings God has given us and making the best use of them in our lives. And as we're thinking about an estate plan, we can think about the best use for those even after we're gone and how they might be used to help carry out the plan that God might have for us and what He might want us to do with the blessings that we have. So as we work with people, it's your goals that direct the activity and what you want to accomplish. It's your plan in the end, and if I sit down and work with you, it's about helping you accomplish what you want to get done, and all of this is confidential. So, most people, when they think about managing money, we tend to think about our cash flow and the dollars that are coming in as we get paid for the work we do, and then the dollars that are going out as we pay bills and other things. And sometimes our giving to church, not sometimes, it falls within there someplace, doesn't it? And so usually people focus on Christian giving, they're thinking about their cash assets. And this is the simplest pie chart you'll ever see. That little tiny slice for most people represents the cash in our lives in terms of what our wealth is made out of. And when I say wealth, I'm not thinking wealthy, but as Americans, we have more wealth than any other people in the world, so it is wealth. But that 2% is the cash. That's our checking and savings accounts, the money that's flowing in and out all the time. And most of us make our gifts to our congregation or other things out of that cash flow. When we're talking about an estate plan, we're talking about, and a gift plan, we're talking about using the rest of the pie. And when we think about the rest of the pie, that's our other assets in our life. Things that include property, investments, financial accounts, life insurance policies, and the personal property that we may have. All of those things usually account for a lot more of our wealth than their cash flow each month. And so what we then do is help people create ways in which they can distribute an inheritance to your heirs, children and others in your life that you want to give to, and then allowing you in some cases to make a substantial gift to the ministry of your choice through this whole process also. So why is a Christian estate plan important? For you, peace of mind in getting this done finally. And sometimes people don't sleep at night as they worry about all these things, and there's not a plan in place, and what would happen if can fall in our minds at times. And so getting it done can bring us peace of mind. It's also a blessing for you, for your spouse and your family. I've met a number of couples where there's a distinct difference in terms of the knowledge of the finances in the family and the knowledge of the assets that they have. And imagine if one spouse were to pass away and the other doesn't understand all of those things like they can or should perhaps. And so working together to put a plan together can also help couples get on the same page and understand their finances together and what their estate plan is. Taking care of this important task is important so that your family won't be left to take care of it later on. And maybe you've been a part of this in your life where you have a relative, a parent or a grandparent that did not have a plan in place, and as a result, there was somewhat of a mess left for other people to clean up. And so it can be a blessing to your family to get those things done. And the creation of certain documents, such as power of attorney documents, is a good plan for your future so that those things are in place and you can determine the person that is going to make the decisions for your health care and for your finances if you aren't able to make those decisions by yourself. And so many reasons to get this done, and so those are some of those. So we're going to move on and talk about some different aspects of an estate plan and what those are, what are some of the main documents and what do they do, and how will they apply to you perhaps going forward. So the last will and testament is, most people are familiar with this just because of the movies, if nothing else, because everybody has heard about a will or a last will and testament. It's the written document that distributes your property after your death. It's also your last word to the world. So whatever you write in that last will and testament is often what your family will read, and it's the last thing you will be sharing probably with the rest of the world. Having a will might determine the level of court involvement. So some people think if I have a will, then we won't have to go through probate court. That's not true, and that's a misconception. If you have a will, you're still going to be involved in the probate process. So what is probate? It's that legal process of distributing a deceased assets, and it's supervised by a court. So I'm very familiar with this at this time because my dad passed away last November. My mom is in the midst of this process of settling his estate and all of the aspects of probate with that, because they had a really small estate and they had a will. Everything's fine, but it can just take some time to accomplish. Probate kind of gets a bad rap because most of us think of it very negatively. In some states and some counties, it can go very, very smoothly. And then at other times you hear people that it takes a very, very long time to get probate completed. But it's just that legal process that has to take place. The courts want to make sure that if there's any creditors out there, they're going to get paid from this estate before the inheritance is distributed. And so that's part of what's going on in this whole process. So they approve the validity of the will. A will also becomes public record when the whole probate process is complete. So I don't know who would do this, but if you wanted to know what happened in such and such's will, you have a legal right to that information. So some families don't want other people to know what was in that will. So I'll talk about that next. There's a window that opens and closes with your last will and testament for bills to be paid to the creditors that are out there. Sometimes they can even come in after the fact and they still have to be paid. It also includes the distribution of your personal property. So if you have items and things and you want to direct where those are gonna go, you can do that as a part of your will. And the will holds no legal authority until after you pass away. So it's a written document, it's gonna sit there. As soon as a death certificate is produced, you pass away, then it goes into action and the probate process begins. So let's see. Again, a will limits the probate decisions that have to be made because it has some direction going on with that, but every will does go through the probate court. And your debts must be paid from your assets before inheritance will be distributed to family. So that's one thing I never thought about before, but those creditors, they're gonna get paid out there. So a last will and testament. So we're very, most of us, like I said, familiar with that, but there's something else called a revocable living trust. So this is usually people look at these two and make a decision of which way they're going to go. Are they going to have a last will and testament, or are they going to have a revocable living trust? So a revocable living trust means it's a trust that's alive while you're alive. It's a vehicle for managing your assets, and a vehicle takes items from one place to another place. In this case, this vehicle can hold the assets that you have while you're alive and transfer them to other people after you've passed away. So also with a revocable living trust, it keeps most of your affairs private, which is different than the will. It can avoid guardianship proceedings that might have to take place and some of those related costs. It provides greater protection and control than a power of attorney document alone. The person in charge of the trust is the trustee. So while you're still living, it's your trust, you're the trustee, but you appoint somebody to be the successor trustee. So after you pass away, that person you've appointed then is in charge to carry out your trust when you're in heaven one day, and they'll then have that authority to do everything that the trust says that they can do. It's called revocable because it's revocable. And you can, while you're still alive, you can make any changes that you want to your trust. You can revoke it altogether and say it's no longer even valid at all. But that's what that means, is the revocability of it, and it's changeable. So once you get this done, it isn't like you can never touch it again. And actually you can change a will into the future too if you would want to do that. And then if you have a revocable living trust, you still need a will. But it's usually a one-page will called a pour-over will. And it's just there mostly to make sure that there was any assets that didn't go into the trust, that there's a direction for them based upon the will as to what to do. So let's say you just bought a vehicle, it's worth 30 grand and you both pass away. There's no direction as an asset of what to do with a $30,000 vehicle. So the court and other people involved would look at the pour-over trust, and that would say what to do with any assets that weren't included in the revocable living trust. So, yeah, so it's kind of a big decision when you would sit down with an attorney to get your plan done, and they will usually ask you, what do you want to do? Do you want to have a will or a revocable living trust? So that's a little bit of the difference. There's things there compared with those. One is court supervised. The documents are public with the will. It can be more time consuming, and that can lead to expense. Sometimes that probate can take a year or more. I've heard of that. With a revocable living trust, it usually costs more. It costs more money to set up now on the front end of things. But when you pass away, it can be a faster process of distributing your assets. Assets in the trust would avoid the probate court and that whole process, and then it remains private. Not private to family necessarily, but private to outsiders as to what was in that trust and where those assets went after you pass away. One is not necessarily better than the other. For some people, the will is the best thing. For some people, the revocable living trust is the best thing. I'm told if you have properties in more than one state, you definitely want a revocable living trust, because otherwise you'd be doing probate in different states for different properties that you have and so forth. But it really depends upon your own individual situation. And here's the one, this is from me because I've seen this happen. So don't let your desire to get a revocable living trust, which can sometimes be 3 times as much as getting a will done, don't let your desire to get that prevent you from getting a will now. Because it's very important that you get a will. And you might want a revocable living trust and you're saying, that's awfully expensive and we don't want to pay for that right now. At least go to the, at least get the will done then, and you can always add a revocable living trust in the future if you wanted to do that. So that would be my recommendation for anyone with those things. So, questions? Yes.
Just a comment that from our own personal experience, but Shelley and I did a will a couple different times over our marriage.
Yep.
Probably 3 times I think we redid our will, and then now we redid it again as part of this process, and we moved to the revocable living trust, partly because our situation had changed to the point of our kids are adults. We also have more assets because of our time, where we are in our life at this point.
Mm-hmm. Yep.
And just thinking about the future, and just plans change over time too. So that could happen to you too.
Mm-hmm.
But I would agree, just having something done is better than nothing.
Yes.
And there's too many people who pass away today with nothing, and things are just a mess.
That's right. Yeah.
So
Yes.
if you do have a will drawn up and then go to a revocable living trust,
Mm-hmm.
is the will null and void then, and the living trust is what?
Yep.
goes?
Usually anytime you have a new will created or a revocable living trust replaces the will, it's the most recent document. And sometimes the very top it will say that this replaces any previous legal documents regarding this estate or something to that effect. Yep, very good question. So, yeah, so things to think about, important stuff. Look, it gets more exciting with every screen. Transferring assets. Property. How is property going to be transferred to your heirs? So that's usually done. It can be done through a title, and how that transfers either to your estate, or in some cases you can transfer property to others through the actual title itself. So you maybe have heard of the phrase joint tenancy. So that's the right of survivorship. So if you're married to someone and one of you pass away, then the property automatically under that goes to the spouse, and the spouse gets to keep the home. So that's a very good thing to know. The best way to protect your property is to have an estate plan. With beneficiary designation in your will, the property can be transferred to heirs without probate. So that's something you'll want to speak to an attorney about, is the properties that you have, and how exactly will that take place? How will they be transferred to our family after we are gone? The second thing on the list is beneficiary designations. And so these generally are included, we're talking primarily about retirement accounts and insurances when we talk about beneficiary designations. And so this can be a little bit cumbersome, but when you open these accounts, it asks who is going to be the beneficiary of this account, and you had to list either a spouse or children or somebody like that. And so you want to make sure on a regular basis that those are up to date and they say exactly what you want them to say there. Anything that you have as a beneficiary designation with a financial institution supersedes anything that you say in the will. So if in your will you say, I want my son to have everything in this retirement account, but then the beneficiary designations give it to your daughter, they're not going to your son, they're going to your daughter. That contract with the financial institution takes precedent over anything your will might say. So some people don't have these things in a line, And so when they pass away, they think everything's set up to go exactly like they wanted to, but they never changed beneficiary designations to fit the plan that they have in place. So the last thing is payable on death or transferable on death. This is usually with brokerage accounts, stocks and bonds and other investments. And then banks, where you have a savings or a checking account, or if you have a CD, those things are usually called payable on death. So as you go into those accounts online or access those in some way, you want to look for beneficiary designations or POD or TOD, and sometimes it's hard to find those places where you can make those changes. So some people, there's a misconception out there also that I don't need a will if I have everything designated where I want it to go. And that's not a good idea on its alone, because if you don't have a will and your children aren't 18, they can't just receive these dollars from these financial institutions if they're not yet an adult. So having a will to state what would happen to those dollars is really important, as well as having the designations in order also to go with that. So, thoughts on that topic? Anyone?
What
Yes.
does that TOD and POD stand for?
Yep, one is payable on death, and the other one's called transferable on death.
Because if you have a bank account, and like a couple of my children are on the bank account, but then also I have a power of attorney to
Okay.
a friend because my kids are farther away.
Okay.
And someone says that the person that's power of attorney could just take all that money if a person dies and the kids get nothing, you know, even though their names are on there for beneficiary.
Well, that would not be legal, so that shouldn't happen.
Okay.
I am not an attorney and I'm not a lawyer. No, those are the same thing. I need to say, I'm not an attorney and I'm not a financial planner. So those kind of people are important advisors in your life. So you want to, if you have certain situations like that, you really want to talk to somebody about that to make sure it's like it should be. So, yep, I'm not an attorney or a lawyer.
The one I talked to is a bank here in town, Chase, and they say that could happen, and it's like, I don't know, you have to get an attorney to fight it, I suppose, the
Huh.
kids would or something, I don't know if they have, you know, a chance to.
Yeah, or maybe you have the wrong part of attorney
And
chosen.
the bank account probably down to nothing anyway, so very much to fight for.
Yes.
Ah.
All right. Wow. Okay, next we're going to talk about caring for family and for your assets. All right, so you can see the phrases up there, the words we're going to be talking about, and what happens if you do not have a will. So, here's the first one. So, for primary responsibilities of the personal representative or the executor. So, when you draft your will, they're going to ask you who's the person that's going to be in charge of this when you die. That's going to be the person called the personal representative. They would have to work with the court and the whole probate process and so forth according to a will. That's the person responsible. So here are the 5 primary things that they do. The list is actually much longer, but I condensed it into 5 things. Number 1, locate and take control of the decedent, who is the person that has passed, to take control of those assets. You need to find all the paperwork and everything related to all the assets that make up the estate. You need to make sure that all the bills and all the creditors are paid before any inheritance is given out. Make sure any and all taxes are paid. And I probably would put number 3 before number 2 because you don't mess with the IRS. Next, locate and communicate with surviving heirs. So this can be a process in some cases because you might be appointed the personal representative, but you may not know of all the heirs. So that can be a big process in some families, depending on how separated they are or things that have happened in the past and so forth, including, step relatives and things like that. And then lastly, distribute remaining assets and close the estate. So this is a big job. I've never done this. My mom's doing it for my dad's estate, which wasn't much, but have any of you ever been a personal representative of an estate?
I'm meeting with an attorney next week to close the estate of a family member that passed away about 6 weeks ago.
Okay.
She had no will.
Oh,
She had no children. She did not have an end-of-life directive until she was in the hospital.
okay.
Fortunately, all of her accounts, retirement accounts and bank accounts had beneficiaries on them,
Okay.
so hopefully that will simplify things.
Yes,
but
right,
We'll
right.
find out.
Yep, yep. It can be a big job, so.
Oh,
I'm named the executor for my
Oh.
mom and stepdad down in Florida, so
Yep.
hopefully it's a long time before anything has to happen that way, but,
Mm-hmm, yep.
But they have willing and things set up, so hopefully it won't be too.
I'm told to make sure that you have at least 2 people chosen to serve in these different roles, because sometimes when the time actually comes to do it, they may not want to do it or have the time to do it, and it has to be another person to do it. So it's good to have more than one person selected, and your attorney should tell you to have more than one name for this too, so, yep. Yes?
Can the attorney do the executor? Can the attorney?
Can the
himself?
attorney?
Mhm.
They probably can, I don't,
Cause I don't think my kids want to do it.
mm.
There's other no relatives, so I don't know who's gonna do it.
That's a very good question, yeah, I don't know. I think most attorneys would refuse to do that because it could be a conflict of interest for them. So
I think
Pastor Dave?
you could probably choose whoever you want if they agree to it, but then if you're choosing an attorney, they're gonna charge you per hour
Oh.
probably for the work they do on that.
Oh, gosh.
So you have to remember that. And it is, I think it's not uncommon for executors to be reimbursed or
Yep, yep,
somehow maybe be paid. And
yep,
like I was the executor for my parents when they both passed away, and I chose not to take anything
Yep.
as compensation, but it's not wrong for them to do that.
exactly.
But I would guess if you pick somebody like an attorney, you are going to be paying out of your estate for their services.
Yep, mm-hmm. Yep. Couple more notes with this. I highlighted a couple things in my notes. The personal representative must file with probate court. So after the person dies, they have to file with the probate court. And then work with the funeral director to obtain death certificates. And they recommend getting 20 of them minimum, because perhaps every single account that they had might require a death certificate before it could go as a part of the estate into probate process. So they said, just go ahead and ask for 20 of them right at the start of the whole process, so.
Keith mentioned too, they aren't free.
They aren't free.
Yeah.
And they're not free,
They're not
okay.
free.
Okay, so that's good to know too, so.
I think they're $3 each, I think.
Okay.
Yep.
Yeah, so lots of duties. You can find longer lists online with exactly what that is. But really, the attorney involved that will be supervising the process probably has the list that you actually have to follow.
Excuse me, a power of attorney wouldn't be a person that you would give that job to, I would guess. That might not be wise.
It could be.
It could be?
It could be the person that was the power of attorney for finance could certainly roll into that responsibility. Mhm.
Because she knows where everything
Right,
is and
right.
all about everything.
That happens a lot in families where the child that is chosen to be power of attorney for finance becomes the executor of the state.
But
That
this is a friend, you know, that,
Right.
you know.
Yep.
Have you found that it's common to have a power of attorney for health and a different power of attorney for medical?
Can be the same person. A lot of families choose differently.
Yeah.
They look at their gifts that their children have and
Mhm.
say, okay, our son Andrew, he's very caring, so we're gonna give him in charge of the medical
Yeah,
side.
yeah.
Our daughter, she married a financial planner, so we'll put her in charge of the financial side. So, not that math is her thing, but her husband definitely. So you can look at their gifts and make decisions about that if it's your children.
Those
Yeah.
5 things you just had there on that, go back one, whatever. And, do you have that listed on a piece of paper that's in this pamphlet?
No, I don't.
'Cause
No,
that's
and
one thing I sure would like to have.
that list, okay?
Is there some way to get that?
I'll write it down for you.
Okay.
'Cause I wrote it down for me.
Okay, good.
All right. Let's see, next, guardianships. Oh, there we were. So, guardians. It's a legal adult caring for the named children in an estate. The basic responsibilities is they have to act in the interest of the minor. They have to provide proper care, including residence and education. They have to provide proper hygienic, medical, and mental care also. So those are the three main things that they have to do. You can also, through your estate planning process, through your will, select a temporary guardian to make sure that your children never have to go through protective services. So if you were to both die in a car accident, you and your spouse, for example, and you don't have close by relatives, children might have to go into protective services until care could be arranged. But you can name the people perhaps that could be responsible in that way to avoid that for your children's sake. You can also, through your estate, it's called confidential exclusion. You can name the people that you definitely do not want to serve as guardians. I never knew that, but sometimes that could be an issue in certain families. Other considerations when choosing a guardian for your children. Faith, of course. Hope that would be number one priority. Are they going to grow up in a Christian household? Are they going to attend church and learn more about Jesus in that family? Parenting style, values, do those things match your family? Is it a good fit or not? Location. If you chose guardians in a different part of the country, a different state, would your children have to move? And is that another stress you don't want to put on them potentially by choosing guardians that are far away? Also, I read that it's best to only think about the next 3 or 4 years. You don't have to think about the next 10 years of their life. Just think about what's best for the next 3 or 4 years for my children. It's good to ask, are your children comfortable with the persons that you are considering choosing? What's that relationship like? Is there a good vibe there? Do they feel comfortable around them? Do you think they'd be happy with them? Consider the age of the children and the age of the potential guardian candidates. How young are your children? How old are the guardians? When our children are 16 or 18, how old will those guardians be? Is that still going to be a good fit or something like that down the road? And then integrity and stability. Are these people that you admire? Or is it a stable family? Would this be a good place for our children? So, wow, it's really difficult, hard decisions to make. But these are some good suggestions I saw. Yes?
I am divorced.
Okay.
And so if something were to happen to me, obviously the father would
Mm-hmm.
have,
Custody then at
custody
that,
or-
yeah. Mm-hmm.
Do you know if then he were to pass away, would his, his wishes just be the ones?
Or would yours be
Or
taken
can
into
I-
account?
Yeah.
That's a awesome question I don't have an answer to, so.
Somebody will. though.
Yes, they will, yes, that's a really good question, yeah,
Good
absolutely,
attorney question.
yes.
Well, I just gotta find one.
And then, of course, ask the candidates if they're willing to serve in this role. And then have at least one alternate if they can't serve in the role when the time would actually come for some reason. So lots of important things to think about. Common mistakes. Choosing people based upon how much money they make. Choosing people because you might hurt their feelings if you don't choose them, like relatives, sisters, and things like that. Not naming alternates. Relying on informal agreements. So like, will you take our kids when we die? Sure. Okay, over a beer or something. That's not good enough. Not reviewing these every 3 to 5 years, meaning confirming with these people that they still want this responsibility as guardians. Not leaving a letter of instruction. You can be very specific and clear about your wishes in these documents, I'm told. And then ignoring what your older children might want. They might have a good inclination about who might be the right people to put down. So it's not bad to consult them on this if you feel that they're of age that could give a good, worthwhile answer there that you trust. So, Any thoughts more on guardianships? It's a lot. That's heavy stuff. Ooh. All right. Next, choosing a trustee of my minor's trust or special needs trust. So, you can create a trust that would be funded after you pass away, that will put dollars in place to care for your children after you are gone. There's a person that will be in charge of that fund. That is called the trustee. And then they would manage the dollars in that fund and make sure that your children are cared for through the funding of that and in other ways. So this could be in addition to the guardianship in some cases. And then special needs, sometimes there's an individual in a family that is going to need special care for years to come, or perhaps their entire life. And so some families put together special needs trusts so that that person can be cared for the rest of their lives. And so if you have those things, you can speak to your attorney about that whole process and how that would take. The instructions for all this would be written into the trust. And then they would have the responsibility of managing the assets. So sometimes you might have a guardian who is responsible for managing the children, but you can have a trustee who is responsible for managing the dollars. And I'm told it can be sometimes a good thing that they're not the same person. So the legal authority comes from the trust. So if the trust is created and this person is named and you pass away, they then have the legal authority in this. And then my last thing was talk to your attorney about all these things. So,
Could
yes.
you back up a second? You mentioned 4 things. If you back up to the first and second thing, like, say you had 2 executors, and you want, again, I don't think there's gonna be money much to worry about, but whatever, just to get everybody paid and everything. I don't know how you choose that second one. I mean,
Oh, to be
how
the
do you
backup
decide
person.
if one is really wants a certain amount of money, or I don't just know how to phrase it.
Yeah.
Wants to maybe do a little wrong, or a little, maybe not a whole bunch of wrong, but hopefully
Yeah.
you wouldn't choose that person, but you never know. This world is kind of fluctuating with the
Those are hard decisions, yep.
gossip and everything.
Yep.
Or
I'm gonna keep going.
people
We can
get
talk
along-
about
what?
that. I'll talk to you about that at the end if you'd like.
Okay, sure.
We'll keep rolling because I want to look at our time and everything and much to go here. But next is, here I forgot, sorry about that. Durable power of attorney. So power of attorney is a legal document that gives someone the authority as your agent to make financial and healthcare decisions for you. So these usually take place when you get your will or revocable living trust. There are accompanying documents that go with this. Financial, of course, has the responsibility of paying bills, taxes, investments, all that. And then the medical has a responsibility of carrying out the instructions that you would have about your medical care. That might be included in a document called a living will, where you would want to determine how you want to be cared for in the last days and hours of your life and what that looks like. So we have a resource on that if anybody would want that. And then I'm going to mention Sarah Stair's name here at your congregation, who is, I would say, your local resident expert when it comes to advanced directives, living wills, and all those kind of things. If you don't have power of attorney, your spouse does not necessarily have automatic authority to make decisions about your health care. They might have to go through a probate process to get the authority to make decisions about what would happen to you. It isn't an automatic in the state of Wisconsin. Crazy. 3 legal, let's say you have children getting older. I think there's a family here with near teenagers. So 3 legal documents to have your child sign when they turn 18. So imagine your 8-year-old son or daughter is away at school, at college, and they are in an accident. So you rush all the way down to, let's pick a different state, Chicago area. You rush to the hospital. What rights do you have at that time for your 18-year-old child? Not very many. It's crazy. When your child turns 18, they can legally rent an apartment. They can charge their own finances. They can buy a car, all without their parents' consent or assistance. Also, you can't see their transcripts at college after they turn 18 too. If your child becomes incapacitated and they don't have power of attorney documents, there could be a lengthy process called conservatorship to determine who has the rights to make decisions about your child. And so the durable power of attorney is something you can have done with your 18-year-old children that would give you the authority to make financial decisions. There's a healthcare proxy available that authorizes medical decisions that you can make on the behalf of your young adult child. And then there's a HIPAA release because you might not even have access to the medical documents or what's going on with your child. So you can talk to your attorney about these things, but highly recommended. I didn't even think about it when our kids went to college, but or moved out, so important things to think about. What do these 8 people have in common?
No will.
Correct.
Michael Jackson.
They died intestate, it's called, without a will. Isn't that crazy? We have Prince, Jimi Hendrix, Aretha Franklin, Steve McNair, Amy Winehouse, Michael Jackson, Kurt Cobain, and Pablo Picasso is the last gentleman on the bottom right, if you didn't recognize him. I had to look it up. So, great stories. You can look up these stories with each of them. Aretha Franklin one is really crazy because there was a handwritten will and then another handwritten will, and they found these in a locked cabinet. They were trying to determine what was the one that they would use, the courts, to decide who gets what. And then 3 months later, they found a notebook underneath the couch, underneath the cushions, handwritten by Aretha herself. And they fought this, and there's a lot of money involved here, both now and into the future because of royalties and everything like that. And she had 4 sons, and they were fighting about which document they wanted to be used for the actual will and last testament. And they argued over all this, wouldn't talk to each other. In the end, it was the 4-page spiral notebook found underneath the couch that was taken as the final last will and testament for Aretha Franklin. So crazy. So don't be that. All right, what will happen to your assets without a will? You've invited the state of Wisconsin to participate and make decisions about your estate. A court will decide how your assets will be distributed based on intestate succession laws. Doesn't that sound fun? That may not reflect your wishes and could lead to family disputes. So each state has their own intestate succession laws. They follow something, in most cases, called per stirpes, which is a Latin phrase, which means to follow a bloodline with the distribution of property. Some of these things were written 100 years ago in some states and never updated. So they don't take into account other considerations about your family. For example, in Wisconsin, if you have a step or a foster children, they don't receive inheritance following this in Wisconsin. So they would be kept out of your, and then if you remarry or have children from a previous relationship, those children inherit your share of the marital property and half of the separate personal property that you have. So you might not think they're included, but they are, based on Wisconsin intestate succession laws. So it's important to have a will in place so you're not trusting the state of Wisconsin to make decisions for you, because it's probably not going to be what you want. What will happen to your children if you don't have a will? A judge, a stranger who does not know the parents, the child, or the relatives will decide who will raise the child. Children may be first placed into temporary guardianship. Anyone can ask to be considered to be the guardian of your children. And all this process takes a minimum of 90 days. So the children are not going to be a stable environment for at least 90 days during this whole process. So, yeah, so it's important stuff to think about. and get those things done. No one would want our children to go through that process. Many people never get it done just because it's, for whatever reason, we put these things off. But so we're here to help. And so what I do is sit down with families and help them think about all these things, help them prepare for a meeting with an attorney to help get all of those documents in place. And then ask them also to consider how much of their estate do they want to leave for their family, and do they want to consider a gift to the Lord for his ministry here on earth when they go to heaven also. And so this process usually takes about 4 individual meetings where we sit down and talk about the aspects of your estate. The first meeting is called our discovery meeting. And at that meeting, we gather information about you and your family. We think about the people that you might want to nominate to represent your estate. We consider charitable giving. We collect information about all of your assets and assemble all that information. We assemble information about your whole entire family and collect that information. And get all those things together and get to know each other better through that process. Also through this process, we can help you with a Christian preamble or a family blessing that can be part of your estate plan, in which you can express your faith in Jesus, the last words that you want to share with your family and why you went through this process. You can include provisions for payment of debt, how your personal property will be taken care of and distributed to people can be a part of your plan. We establish or discuss the trust funds and different things like that, and nominate the trustees and help you with that process. Utilize tax planning techniques as applicable to help you through this whole process. And so through the different meetings together, it helps prepare for that attorney meeting, hopefully saving you time and cost when you finally sit down with the attorney to get some of these things done. Our second meeting is called a plan design meeting, and what I would do in this meeting is to sit down with you and bring this information back to you along with some ideas about distributing your inheritance to your family and giving to ministries that you might care about. And so there's a lot of different ways to do this, and we have a lot of different tools available to us to help that take place. One of those is called a gift letter, and it's simply a letter on file with the LCMS Foundation that says any dollars received from this estate to the LCMS Foundation when you pass away and go to heaven are going to be distributed to Peace Lutheran Church or other ministries and charities that you care about in that process. And so in that way, when the dollars are received, and you can be assured that through our attorneys and other trust administrators and people like that in St. Louis, we're going to carry out your wishes just as you want them to be. Some people, depending, but a lot of families I see will think about ministry or the Lord or however they want to phrase it. They think about adopting ministry or the Lord as perhaps, in our case, it was our third child. So when we put our plan together a few years back, we decided that since we only have 2 children, we wanted to adopt ministry as a third child. So that meant that now our distribution of our assets are going to go 1/3 to Andrew, 1/3 to Becca, and 1/3 to the ministries we care most about in our lives. And for us, one of those was Camp Luther, and the other one was NEW Lutheran High School in Green Bay, where my wife went to high school. And so those are our choices a part of that. So we just divided it in 3 ways. If you have 4 children and want to add a 5th for ministry, that's a nice way to do that also. That's a simple way to do a bequest and leave a gift to ministry if you would want to do that. These things are revocable and can be changed in the future. So that's important to remember. And then in our summary meeting, our 3rd meeting, we talked about your gift, your documents, the ministries that you want to support, an attorney authorization form, meaning that gives me the authority to communicate with your attorney and help assemble your documents for your first attorney meeting. We affirm your plan, we prepare for your attorney meeting, and then we encourage you to share your plan with your family so they're not surprised when you pass away what your plan looked like. And then there's an implementation where we sit down with an attorney and review the documents, any follow-up that needs to be done. We have some of the documents that might go to the LCMS Foundation regarding your giving. The other documents will be things like your will or your revocable living trust and so forth. There'll be documents you'll work with your local attorney on and get signatures and get all those things completed as a part of the process. So one of the advantages of this is to have, I'm called a planned giving counselor, because we kind of walk alongside you in this whole process and help you get it completed. And a lot of people never get this done, but knowing that I'm out here and I'm contacting you for our next meeting and we have one on the calendar, it helps to get things done and help you get to the process of getting this completed for yourselves. And so that's one of the benefits of going through the process together also. When do you update your estate plan? Anytime there's a significant change in your life, a real estate purchase, a marriage, children or grandchildren, your interest in ministry might change. You might have health concerns. You may have received an inheritance. All those are times and opportunities to think about your gift plan and your estate plan and what you want those things to be and what they look like. By the way, do your own parents have a will or a revocable living trust in place? Something to think about. So it's a good opportunity to review. So top priorities for you: get your last will and testament completed. Think about the guardianships, who you'd want to be in charge of your children, who would serve as personal representative, who could serve as power of attorney. Consider setting up your revocable living trust and a minor's trust if needed for your situation, depending. And begin your lifetime plan for giving journey, which is those 4 meetings with me to help you get through this whole process. So we offer confidential, comprehensive planning, shared values. We become part of your team and assist you with this whole process to get it completed. I'm on the wrong page. Create a plan to bless your family and to bless ministry, guide and walk with you through this whole process. There's no cost for my time to assist you with this whole thing. It's a ministry of the church, and we're just here to help people get this done and get it completed. Your local attorney will still charge you, and everybody expects that, but we can help you get ready for those meetings and hopefully help you save a lot of money in the whole process. So. From Proverbs chapter 15, verse 22, plans fail for lack of counsel, but with many advisors they succeed. And so we see ourselves as counselors and advisors to help you get this process completed and get it all done. And it's so easy to procrastinate and to put these things off, but we're here to help. So this is my crew, 4 grandkids and 1 on the way in September. So they're the blessing in our lives. So in your booklet, the last page is a short survey about our meeting here tonight. So if you could leave that contact information there, and if one more form, yeah, it's the form I think in the last one there. So if you could fill that out before you leave, I'd really appreciate that, with your name and other information. That'll give me a chance to contact you and follow up and see what you'd like to do. There's no obligation, you don't have to do this, of course, but I'd love to help you get this done for your sake and your family. So, yes?
There's one thing you didn't mention, and that's can't pronounce the word.
Irrevocable.
Like if you have a burial plot, let's see, what else is there? Funeral, you wanna pay for that? You know, when you're earning money, you know, and you're putting it in the bank, or
Yep.
you got extra, you better put it in that that word.
An irrevocable fund, yeah.
Fund, because if you fall in hard times, they try to take it away from you, the
Oh,
government
okay.
will. They
Mhm.
tried it for me, and so many times.
Right.
By gosh, if we didn't, it would have been gone, you know? And, so.
That's really good. Yep.
Protect yourself,
Yeah.
you bet.
Yep. Some people set those up directly with a funeral home also.
Oh, yeah, definitely.
So then when you pass away, that's all covered and you don't have to worry about those expenses, and it's really nice for the
Cause
family.
I was working down in Green Bay and, I was, you know, bringing quite a bit of money home and so forth, and, I kept putting in a checking account and so forth, and the bank people said, oh, you should put it into you know, when it gives you more interest or such.
Sure.
And I thought, well, this would be a good time to put something for a funeral fund. I won't be always earning all this money, you know?
Right,
So that's what I did.
okay, good for you.
Yeah. So it helps an awful lot when it comes to paying bills. you know,
Yes,
at the end.
good, good. Other questions that come to mind, anybody, or anything for me? My card's in there also. I will send you an email, either tomorrow or Friday, and I'll give you a link in there. If you'd like to click on that, you can see my calendar and you can set up your first appointment with me if you'd like to do that. Very simple. Usually 1.5 to 2 hours together for their very first time, and then collecting information and talking through things, and